Hello, in this session I will be providing you a brief outline of the stream on administrative law. Modern democratic state is not a mere police institution, but an active participant interfering in almost every sphere of individual and corporate life. The notion that administrative power threatens democratic governance persists. The aim of administrative law has been to make the administrative state function in a manner more compatible with our democratic commitments. Thus, this stream will highlight the importance of administrative law in the functioning of administration, trace the emergence and development of this branch of law, involve study of rules and regulations applied in the functioning and control of administration. The lessons learned through this process can in turn be used to improve future decision making, bringing fairness, openness and transparency in functioning of administration. The objectives of the stream are to explain the principles, standards and doctrines developed by the judiciary as custodian and guardian of rule of law, to apply the fundamental constitutional and legal requirements in their rule making and decision making functions, to state the principles of proper and rational exercise of administrative discretionary powers, and to communicate recent developments in the area of judicial review of administrative action, law relating to liability of administration and to departmental inquiry. In total, there will be 10 sessions in this stream on different aspects of administrative law. The introductory session on administrative law, nature and scope will provide relationship between public administration and public law, also deal with the meaning, definition, scope and significance of administrative law, evolution and development of the law, basic doctrines which are applicable, relationship between constitution and administrative law, and finally the classification of administrative actions. Nowadays, maximum rules and regulations emerge from administrative rule making. The session on delegated legislation will help understand the concept and growth of delegated legislation, rules and principles of administrative rule making, control mechanism of delegated legislation and the limits on sub-delegation of this power. The rules which administration must follow to give minimum protection to the rights of the individual against arbitrary procedure is known as principles of natural justice. The topic of principles of natural justice will give an insight into concept, evolution and importance of principles of natural justice, application of natural justice and the principles recognized under this over the period of time. To carry out vast functions of welfare state, large discretionary powers have been vested on the administration. The session on administrative discretion will provide meaning and definition of administrative discretion, outline control mechanism at the stage of conferment and exercise of discretion. The topic of judicial review of administrative action will present the concept and meaning of judicial review, its constitutional basis, the grounds and remedies available for judicial review. This will provide an overview how the power of review is being used by the judiciary to keep the executive within its bound. With overburdened courts and pendency of cases, resolution of disputes through various statutory tribunals is being resorted to. Session on administrative adjudication through tribunals will explain need and importance of administrative tribunals, definition, constitutional status of these tribunals and the rules and principles applicable to the tribunals. The mechanism of administrative adjudication will also be highlighted in this session. Civil servants are indispensable part of governance. Certain safeguards are built in constitution to protect them. The topic of constitutional safeguards available to civil servants will elaborate constitutional provisions relating to safeguards for public servant, need and importance of these safeguards and legal principles laid down by courts regarding condition of service of civil servants. How far should the government be held responsible for the acts of its employees? This will be examined in the session on vicarious liability of state. The session will explain doctrine of vicarious liability, liability of administration for torts committed by its servants, constitutional provisions relating to it, extent of liability of state and changing trends in judicial interpretation as far as India is concerned. Nowadays, the government is entering into a number of contracts daily to carry out its function. Session on government liability under contract will focus on legal basis for contracts, constitutional and statutory provisions for contractual liability of the administration, and judicial interpretations of the same. As you all must have noticed, the public interest litigation is emerging as tool for examining the arbitrary actions of administration and protection of vulnerable. The session on judicial activism through public interest litigation will provide concept and meaning of judicial activism, development of judicial activism in India, constitutional basis and procedural innovations by judiciary to give relief to the affected people. The mode of evaluation for the stream will be case comments. 2 case comments are required to be submitted by each participant, as this will be an individual exercise. With this, I thank you all for watching this video.